Is third-party culprit evidence in or is it out after we watch the charging instructions in the Karen Reed case? Let me explain. Hi, my name is Stephanie. I'm a criminal defense attorney, and I, like many of you, are obsessed with the Karen Reed case. Now, I can see why many of you are confused about the third-party culprit evidence, and let's chat about it. Third-party culprit evidence is out. However, Bowden evidence is in. Now, if you remember us talking about this on my live a couple of times, Bowden evidence is when there was a faulty police investigation, and the defense can talk about the faulty police investigation, meaning that they should have collected evidence better, they should have interviewed other suspects, they should have worked more on chain of custody, basically just that they did a shit investigation, and in doing so, they failed to follow all leads, they failed to do what they were supposed to do, and in so much as that they should have done that, they failed to do what they needed to do, and therefore, if they had done that, we would not be here, right? Now, I talked about this in a video probably 2 or 3 weeks ago, and it turns out that what I had said about the Bowden evidence and the third-party culprit evidence actually is what's going to happen. So let's put up the law and let's talk about it. So when I say that the third-party culprit evidence is out, it is out in the way that they cannot say Brian Higgins committed this crime, Brian Albert committed this crime, and Brian Albert committed this crime, okay? So legally, third-party culprit evidence and Bowden evidence are distinctly different, okay? So this is the distinction. Third-party culprit evidence is used to suggest that someone else committed this crime. Bowden evidence is used to suggest that the evidence at trial may be inadequate or unreliable because the police failed to conduct the scientific tests or pursue the leads that a reasonable police investigation would have conducted an investigation, and that these tests would have led to significant evidence of the defendant's guilt or innocence, right? So that's Bowden, all right? That information is not hearsay because it's not offered for the truth of the matter asserted, but simply to show that the information was provided to the police. Therefore, it doesn't meet the standard evidence regarding a third-party culprit, which basically means here that the defense can infer and say in their closing that they had evidence that Brian Higgins had motive and they did not follow up on that, okay? And they have been laying the framework for that the entire trial. They can lay the framework that there was another individual who may have committed this crime, Brian Higgins, and the police did not do a proper investigation to determine whether or not he could have been involved in this. They can't say he did it, which would be third-party culprit, but they can say that the police failed to follow a lead that could have led to someone else, okay? This is the case law. We have Rosa Roman, which is judge properly refused to permit hearsay as third-party culprit, but permitted same statements to be introduced as part of a Bowden defense with limiting instructions that they could not be considered for the truth. And then we have Reynolds, which is where the judge should have permitted the defendant pursuing Bowden to question police about tips from CIs because the defendant was not offered about substantial tips of the informants for the truth of the matter asserted, okay? Third-party culprit evidence may be admitted regardless of whether the police knew that the third party, whereas Bowden evidence is relevant only if the police had learned of information during an investigation and failed to reasonably act upon it. That is where Bowden and third-party culprit differ, okay? Which is exactly what we have here. Here, the police learned that Brian Higgins could have committed this crime, but they did not act upon it, okay? Accordingly, the judge must conduct a voir dire, determine whether the Bowden evidence had been furnished to the police, which it had been, and if so, the probative value is substantially outweighed by the risk of the unfair prejudice to the Commonwealth from diverting the jury's attention to collateral matters, which has been done. And Bev is going to let them do this, okay? Unlike third-party culprit evidence, there is no constitutional right to present a Bowden defense, and the exclusion of such evidence is reviewable only as an abuse of discretion. So, what does this mean? So, in essence, they are not allowed to present a third-party culprit defense, meaning they can't get up in their closings and say, Brian Higgins committed this crime. But they can get up in closings and say, The police were given information such as the fight at the waterfall, the texts to Karen Reed, her ignoring him at the waterfall, the text to her at the waterfall, the well text message, the to Judd O'Keefe at the waterfall. And they were given all that information, and they did not investigate whether that man had anything to do with this crime. That's the distinction between the two. So no third-party culprit, but they can say that the police did not do their job and investigate, which circumvents third-party culprit but puts the idea in the jury's mind. That's a win for the defense. That's a win for the defense. Do you think that this was a fair decision? Let me know in the comments, and let me know if you understand. All right? Let me know if you think that this was a fair decision. So I'll see you guys tonight live at 6.